Hey, Council, how are you doing? Let me approve Council so we can test our audio and see if we're good to go. Council, can you hear me? Council, can you hear me? Are you able to hear me? Hey, Council Philip, nice to see you. Nice to see you. Nice to see you guys. We're getting started. I'm still sharing the link out here so we can have as many people as possible. Let me also approve Council Philip here. I just want to confirm if our audio is clear. That's the major thing I want to confirm. And once we are good to go, then I'm just sharing out. Hi, Mugara, how are you doing? Council Philip, can you hear me?
Yes, I can hear you.
First and foremost, I want to report to Council Alan that you did a very amazing job last week. We had a fantastic show. Lots of people did appreciate. I just want Council Alan to know that you really treated us so well and you gave us a lot of information for that day. So we really, really want to thank you so much for what you did for us. So, ladies and gentlemen, tonight, over land disputes, key points to consider as you prepare for that. So, but just in a minute, allow me, I'm still sharing the link out for people to be able to join in. This episode is brought to you by Amity Realtors, a real estate agency from Western Uganda. And of course, for many of you that are looking for farmlands, if you're out there looking for agricultural land, you're looking for commercial plots, you're looking for prime plots within Western Uganda, Amity Realtors is the real deal for you. I want to welcome Ntambi, Karim Ntambi. You're most welcome. Thank you for joining us. We hope you can be in for this discussion. We always talk land matters every Tuesday, 8 p.m. to 9 p.m. And tonight we're going to be discussing going to court over land disputes. What are the key points to consider when you find yourself in that situation? Council Alan, I want to hear from you if you can hear me well, and I want to hear your voice tonight. Council Alan?
Yuga man.
Yes, Phil.
I wish to add my voice to welcoming Ntambi Karim. He's my brother, based in the US.
Oh, fantastic.
Yeah,
Yes.
I'm happy to see him on call.
I think Council Alan muted himself and he has not unmuted. I hope he's not speaking in silence. Okay. Okay, cool. He's here. Council Alan, can you hear me?
Yes, Fred, I can hear you.
Oh, fantastic. I was getting worried. I was like, Council is here, but he could be talking to himself and he has forgotten to unmute.
No. I was just trying to set up, but I was listening in, and I would like to send my appreciation to my colleague and friend, Mr. Philip Munavi, Council, for having done justice to the topic for last Tuesday when I was not able to join in. I have received feedback, and people are happy that he was willing to share much of the information that he had.
You should
So
be
thank you very much, Philip.
worried. You should be worried. You have a dangerous substitute Council. Aren't you worried about that?
That's not a worry. That's not a worry, Yuga man. That's not a worry. That's cause to celebrate.
Okay. worried when there is someone who can do justice to the things they do justice to. Anyway, that was just on the side. But Council, we are happy to hear from you. How are you doing? How is Imbara?
I am okay, Fred. Bara is good, and the rains, of course, are doing their toll on us. Nature is fighting back, but yeah, we are hopeful and we are moving on. Bara has been good. Of course, the weather has gone quite too cold, but what is notable is that the volumes have risen in the nearest river here, River is, and some people's houses have had the effect of the weather.
Okay, great. So, Council, tonight we're going to be looking at going to court over land disputes, key points to consider. And I think this is one of the most important topics for me as an individual. And the reason is many people and they even get to a point where they fear to just go and seek for justice. So I think that will be listening to this show thereafter or even live will actually be able to pick out something. But Council, first things first. Are
Yes,
land
Fred.
disputes a must that is sorted in court? Let's start from there. Why court? Isn't there another alternative without going to court?
Thank you, Fred. First of all, when we talk about going to court, we have to note that usually not all the land deals or land disputes that we have should end up in court. And today we shall be considering the effect of going to court. Before you go to court, what other remedies can you consider? Usually we talk about alternative dispute resolution. And here we talk about the other mechanisms that are available to us or to people who have a dispute in land through which they can be resolved. This could be through mediation. Mediation necessarily does not need to be in court, but usually you call parties and then you have a neutral person listen to both sides and then come up with a suggestion that may be agreeable to both of them. Usually here in mediations, we talk of a win-win situation. Somebody coming to mediation should be ready to compromise. And the courts have adopted this. And once you have filed your case in court and you seek an out-of-court settlement, you will not be bound by the rules of procedure or the legalities. You will sit down, court will give you a mediator because we now have what we call court accredited mediators, and they will also guide you. So that's one of the ways, but the others are quite many, and they still include even if you have a religious leader who is going to sit you over this matter and you talk about it. Through our various series, we have seen that some of these disputes could be handled otherwise. If it is titled land, we have seen you could caveat the land. Sometimes we've caveated the lands and people have come to a round table and found a solution. In other instances, the remedies are there. We talked about them occupying your land and all that. But today, I would like us to specifically focus on going to court and what it entails. Number one, I would like whoever is listening in to note that you do not just walk into court. When you think of going to court, you must have what we call a cause of action. You must have a cause of action. You must have suffered damage or injury or loss as a result of a dubious land deal or engaging in a land transaction. And then after that is because all that has been caused by whoever you are suing, rather whoever you are taking to court. So unless you have suffered any loss, damage, you do not have what we call a cause of action. So many people will come and say, this man, this land, my land. They tell you a lot of facts, but for us lawyers, what we look out for is, do you have that cause of action that takes you to court?
Thank you, Council. Thank you for that. Council, you're talking about something that is very, very key. I'll give you a real example because sometimes it's very important to also think about these scenarios in real life. Today, we have a very big problem that the police, the army, actually now I even see people contracting private security to deal with land issues. And this has escalated a lot of problems within our communities. People have shot at each other, people have died, I just wanted, as we get started on this journey, maybe I just wanted to know what your advice would be, because I know a lot of people who think when I have a land issue, I will straight away go to police, report, and get a person or a police person to keep this land. Would you talk something about those scenarios, because they are too rampant and they are too common in our communities, just as we get started, so that people know that when you have a land dispute, maybe if you go to police, this is what you should be doing, but not to pay police to come and protect that land. Or would you be able to say something on that as we get started into this conversation?
Thank you very much, Fred. What people need to know is that, like I've said, not every dispute in land has to be taken to court. Some of these disputes can always be settled out of court. The most important consideration why we encourage people to settle disputes out of court is there are about two or three. Number one is the cost of litigation. Litigation is expensive because in most cases you are not going to conclude a land deal, rather a land case, within a year. It will be magical for you to complete a land case within a year. The minimum, the land cases have taken some maybe 3 years or 2 years, but most land cases have stretched and have gone up to 10, 15 years, 5 years. So when you are in court all that time, you are spending on a lawyer, on yourself, and this land is actually in most cases not generating any income, because many protracted land cases usually have what we call interim orders, temporary injunctions that probably even bar further developments on the land. So all that is money you are losing. Apart from the money you are injecting in, you're also losing other money. Now, that's why we advise people that please, if possible, avoid court, engage ADR, seek alternative dispute resolutions. Secondly, most of the land wrangles that we have that have usually gone to court, you are going to find that the dispute is a family or even close friends or business associates. Something has gone wrong and these people cannot mend their relations simply because of a land deal. So for us to promote harmony, because law does not operate in a vacuum, there must be a society, and society lives on cohesion. So unless the society is together, then the law will still not operate, because you're going to have what we call anarchy. Imagine brothers fighting over a piece of land that they inherited from their late father. We have seen that even the murder cases that we have today, many are linked to disputes that are related to land. So we believe that when parties choose to go for mediation or arbitration or any other dispute resolution mechanism other than coming to court, this is going to be saved. Their relations are going to be kept together, and ultimately, we are promoting a society that is cohesive. So that is why we have always recommended people, please consider ADR whenever you have a dispute. Do not run to court. Okay. Now, about the other various offices that you are running to, the police, the RDC, and all that, I'll emphasize this, that RDCs in land matters are mere mediators. RDCs in land matters by law, they are simply mediators. They are not a court of law, and they cannot make or give a binding decision on a dispute in land. Their role is simply to guide. They do not have the force of law. They don't. A lot of decisions have been made and a lot of interpretations have been made. I know the practicability of it, but that is the law and it is what it is. A decision by an RDC does not have a force of law.
Cancer, I was about to come in. Like I said, today's topic, I think, is one of the most painful things. There are a lot of Ugandans that own land with maybe a little bit of disputes, are each actually struggling with every single day. Now, practically, we've had scenarios, and I just want to have good advice from you. We've had scenarios where, you have a land dispute and the person you may be trying to engage brings you an RDC, and the RDC comes with the police and puts all these orders: don't do this, don't do this, stop this activity. I want you to just give us that assurance that the RDC's office is a simple mediation, because sometimes they come with a lot of force and they enforce it looking like it's a legal process. And in that case where someone is actually stranded between believing what the RDC is saying and going going to court to seek real justice, what would you say to people who are going through that, and how should they be able to play with it? Because these RDCs seem to be having an upper hand actually when it comes to some of these conflicts within our communities as regards land.
Thank you, Fred. If I had a land dispute with my good friend Philip Munavi and invited the RDC, something I believe he would not do, we have always advised, number one, give audience to the RDC because of the high office he holds, being a representative of the president in the district, and also being the chairperson of the security committee of the district or city. But we have always cautioned these RDCs, always follow the law. If there is a court order, let us have this RDC be informed of it. Many people, when they go to the RDCs, actually what they are looking for is not a remedy. Some have run to these people because they know they have the full force within the district, that is the armed forces. They can command them. They are at their disposal. So many RDCs have found themselves in a place of conflict. Somebody has come to you because you have the force of the law, you have to protect them. Unfortunately, many have not done any single research concerning the matter. So we have always advised, that RDCs will mediate. If there is a court order, it will be respected. An RDC may give orders that are probably way beyond their reach, but these have always been short-lived. We have also seen RDCs who have suffered personally because of their illegal orders or unwanted or unwarranted orders. So as we go to court, when you see somebody dragging you to the office of the RDC, please keep in mind that it's just a mediation office. It is not an office that is going to give a legally binding decision. Now, where police comes in, and this is where we need to be keen. When you look at our legal system in Uganda, we have what we call the civil system and then the criminal litigation system. Now, in criminal litigation system, basically what happens here is that you are accused of a crime which is stipulated in the law, and there is a punishment for it. This is where police comes in. Police is supposed to investigate where a crime has been reported, and then if the investigations are thorough and there's evidence gathered, arrest you and have you charged with such a crime, then arraign you in court, and then you are put to the stand, to the test, to defend yourself against such allegations of commission of a crime. Now, in relation to land matters, there are various crimes you can commit or you could be charged with. So sometimes you'll see the police coming in and they're arresting people and you're wondering, it's a land matter, but it's civil. Yes, because there are some crimes that are related to land and have been stipulated by law. Some of these include intermeddling with the estate of the deceased. We saw that in one of our shows here. If you are probably trespassing or selling off or wasting the estate of the deceased person, you could be charged with such a case of intermeddling. Then we have seen criminal trespass to land, malicious damage to property. I have my eucalyptus trees, but because we have a boundary dispute, you cross into my land and you're slashing down all my eucalyptus trees. That is an offense within the law. So I'll go to police, report commission of a criminal offense, make a statement, and then you will be summoned to also give your side of the story. Fortunately or unfortunately, our police today, in most cases, will just come and arrest you. The alleged perpetrator, you will be taken to court, and the criminal process will begin and do its way. Now, that is the criminal process. But in a civil process, if it is a land dispute and it is a boundary dispute, you do not go to police. If there's no element of a commission of offense, you do not go to police. You run to a court. You run to a court of law. When we talk of courts of law, we are talking about magistrate courts, the high court, and superior courts. But the starting courts are usually the high court and the magistrate's court. When you are going to court, you have to think of two things. Number one, what is the price of my land, or what is the value of my land? If you know the value of your land, then it is going to help you to know which court to go to. We have seen in our previous discussions that a magistrate grade 1 is not going to handle a matter that is beyond 20 million shillings, and the chief magistrate will not handle a matter that is beyond 49 million shillings. It is only the High Court that can handle matters that are above 50 million shillings. So when you are filing in court, you are going to be required to state the value of your land. That is how you will determine which court to go to. Now we have these courts spread out in the country. If your land is in Wakiso, there's no way where you're going to have to file your case probably in Masaka. There is a magistrate's court, it is a 20 million land, then you will go there and file in that court in Wakiso, but not in Masaka. There are only a few circumstances where such cases could be transferred. Let's say transaction happened in Masaka, but usually it is the land, it is the place where the land is located that you are going to file that case. So as you go into court, have that into consideration and be aware of the value of your land. The effect of you filing a suit in a wrong court is that that case is going to be dismissed before it even takes off. We have seen so many cases being dismissed simply for having been filed in the wrong court. So you have to be keen, disclose to your lawyers all facts pertaining to this case. We have seen in some cases people buy land and then they want to underdeclare the value for various reasons. So if this comes up that you have underdeclared, a court of law will be like some of you, if you've engaged with insurance. If you have underdeclared the value of your car such that you can pay lower premiums, then you must be ready to receive little compensation because the compensation is going to be based on the premiums you pay. So back to land and courts. If you have underdeclared your land, you cannot come to court and now begin pleading that, look, your worship, you see my land is 5 billion. So I want damages worth that. I've not if it is what you declared at the start that your land was worth 20 million, you are not going to come up and claim now that it is 20 billion. The moment you do that, a preliminary objection is going to be raised and your suit will be dismissed. So having gone to that and you've seen which court to go to, what is the next key element to consider? In court, we deal with evidence. Unless you have evidence, you may not be able to win a court case. The court is not all about sentiments or emotions or what. The key elements are two, the law and the evidence. That is what the judicial officer is going to be evaluating. You must know the law. It is your land, you own it, you're entitled to quiet enjoyment. Somebody has trespassed on your land. Okay, that is the law. Now, argue the facts out. Show us the facts. Do you have proof? evidence is going to be adduced in usual about 2 or 3 forms. One, you might bring what we call documentary evidence. You might bring documents to prove that this is my land. Where is your land? Where is your certificate of title? If it is not titled land, do you have a purchase agreement? Now, if you don't have those, are you going to call witnesses to testify that yes, we have known this gentleman to have lived on this land for so many years and we know the boundaries of that land? Because the beauty with an agreement or a certificate of title, it is probably going to show the boundaries or describe how your land appears and how the features that are on it. So once you have sieved out this evidence, we have seen so many people with very good cases, but unfortunately, when you test it on the bulk of evidence, you find that actually this person may not successfully win this court battle. Reason being, if witnesses are dead, by the time you purchased, all witnesses were dead. Nobody has ever seen you occupy or use this land, but you're here claiming ownership. You have been an absentee owner. You do not have a certificate of title. So all this comes into play when we are considering the nature of evidence, and it must be noted that court is all about evidence. In this, you must have those key witnesses. You must be sure that there are witnesses who will be on your side. I am not saying that go and buy witnesses, because we have seen cases where we have reported a good case to court. Somebody assures you, I have people who will testify on my behalf. On the day of testifying in court, somebody is grappling, is failing to get such witnesses to come to stand. And then if you're talking about witnesses, are they credible witnesses? Is court going to believe them? Because you cannot have your wife as a witness. Okay, you will have your wife as a witness, but how much credibility is court going to give to this person? Because you've lived together and all that. Court is going to say, okay, she's your wife. What else would she have said? Is your husband? What else would he have said? So you must have what we call independent witnesses. And here, usually, we look to the offices of the local authorities. These include the area chairperson, the registrar, and any other office that deals with land. All these can come in to prove a fact or an allegation. Important to note also is that the burden of proof lies on the person who is alleging a fact. That is in civil proceedings. The moment you allege a fact, the burden is upon you to prove. If you say this is your land, you bought it in 1990, prove. Do not expect me, who is disputing that, to prove. So once you have proved that it is your land, now the burden shifts to me to say, okay, look, yes, you bought it, but I had bought before you. Here is my agreement of purchase as well. So all those are considerations you must keep in mind and not simply walk into court. Now, the other consideration is, we call it the nature of pleadings. How are you going to go into court? There's so many various modes through which lawyers go to court, but the commonest with land matters is a plaint. Now, in a plaint, to deal with a dispute in land, the moment you allege that somebody fraudulently probably occupied your land, took over your land, converted the title into their names, and all that, the key element here is you must detail all those elements of fraud. Of course, this sounds so academic for people who may not know, but we are welcome to questions. But what we are saying is that, look, detail, tell us by registering this land into your names without my consent. That is a fraudulent act. I was not aware. It was not with my knowledge. And then secondly, you had knowledge and you had notice that I was seated on this land. It is me who has this house on this land, but you came and mortgaged it to a bank. So all that is notice that imputes fraud. Detail all those facts in your pleadings when you are telling your story to court. How somebody came, mortgaged your land, and took over the land. Tell court that I actually have a residential house on this land, and I have lived there for the last 10 years. So there is no way somebody came who rather could come and claim this land without knowing that there's somebody living on it. So from that, court can always impute that there was fraud, unless of course other facts are always what argued. Are we still together, Igaman?
Yes, Council, I just have a simple interjection there. You've mentioned of the value, like before you go to court, you need to know the value of your land. And I imagine people whose land has not yet been titled, in different areas, maybe depending on the nature of land that you own. Are you suggesting that before maybe I make any attempt to go to court, I need actually to ascertain the value of my land? And also, you've talked about overvaluing and undervaluing. Is it now necessary for me to look out for a land valuer? Can a surveyor help me do that? Because I can imagine we, the common people, sometimes we don't have the actual value, especially if that land, say, for example, was left to me by my late father or by my late parents or grandparents. How would I ascertain that value that could still stand valid in court?
Thank you, Fred. The best way to ascertain the value of land is to have a valuation report. There's no shortcut to that. Although for court, sometimes we are not looking for the exact value. We are just looking for an estimate. The moment you estimate your land, and this can sometimes be inferred. Court can even take judicial notice and say, we all know that an acre of land in this area costs between this and this much. So if we say an acre of land within Mbara city probably costs 50 million shillings, and you have 2 acres of land within Mbara city, and you are telling us that, look, for me, my land is 20 million shillings or 19 million shillings, everybody is going to ask you, where is the location? Is it in the city? Is it in the central business district? Is it in the outskirts? Then the next question would be, how big is your land? So court at times can actually take judicial notice of the value within which this piece of land could fall. But the best way to always prove your case and prove the value of your land is to always have a valuation report. When you're filing in court, if it is not in dispute, you can always simply estimate. If you estimate and you fall within the ambit, you will be good to go. But the challenge is estimating and you are really undervaluing your land, like the example I've just given above. So, moving on, if you really need to prove or dispute, actually, the valuation reports are usually used to dispute the jurisdiction or the value. I could report to court and I say, my land is valued at 25 million shillings. But the person who is disputing, or the defendant, let's say, says, no. This land is not 25 million shillings. It is actually 100 million shillings. Now, the burden has shifted to that person to prove. Now, it will be that person to carry a valuer or a valuation report and bring it to court to prove that, no, look, whatever this gentleman is saying, it is a lie. Now, when they're valuing land, there's so many other considerations the valuers will put into, that will come into play. For example, we shall look at the location of the land. Of course, the size will come in. And then thirdly, the developments on the land. Of course, the tenure will also come in. Somebody who has a chivanja may not hold much value as somebody who has titled land. So all those will come into play, and then a valuer will give you a round figure to say, okay, this land could be between 110 million or 150 million, depending on the following circumstances. And when we go deep into that, we have what we call first value, resale value, and all those. So all that can be taken into consideration when determining the value of the subject matter, which is usually the land. Now, once you have done that, you need to note that there are key timelines for you when you are going to court. Going to court is a serious business and it is not a joke. The law is meant to operate. So what does it mean? Whoever decides to go to court, you must be serious to litigate your case. This is they are what we call the rules, the civil procedure rules, which have been interpreted in so many cases to mean to be handmaidens of justice. They help you navigate justice. So these are rules that have been established that we have to follow, and if you don't follow them, there are consequences. The most notable rules are those within which you're supposed to file your case, then file your reply and file your defense. If I have filed my case in court and served you my plaint or summons, you have within 15 days to file your defense. You do not file your defense, I am going to go move court and tell court that, look, this gentleman, I served him with the documents, but he's unserious. Can I proceed in his absence? If all requirements are there, that is proof that I served you and you have not turned up, court is probably going to allow me to proceed and prove my case in your absence. Now, we all know that natural justice calls upon both parties to be heard. But if you've been given an opportunity to be heard and you have not turned up, you have failed. It is a failure on your part, and you're not going to blame anybody for it. So those are important timelines that you have to respect. The other most important one is a recent amendment of the law, and this is key because it has come to bite. The courts are using it to prevent so many cases from being filed in court. Ordinarily, we've been seeing people, he files a case in court, then he files an application for an injunction. The moment he gets a temporary injunction, he's no longer interested in the case. So court is saying once the last of the defenses or pleadings or actions have been done on the file, you have only 28 days to take the next action. And that next action is for you to apply to court to give you directions on how you are going to present your evidence, to present your case, to urge out your case. So if you don't file that application within 28 days, it is an automatic order of the law that your suit has abated. When a suit has abated, it simply means that your case is no more in court. It's like death. You have died. If you've played some of these video games, they say you are out of your lives. So you have died. After 28 days, no action on your file. You are the one who filed the case in court. Your suit is dead. It is no more. It is going to be dismissed, and in most cases, it is dismissed with costs. That is an important timeline for anybody wishing to file a case of land in court. So if that suit has abated, your only remedy is to file a fresh suit. You do not even have a right of appeal. You do not even have a right to apply to have it reinstated or brought back to court. That has automatically abated, and your remedy is to file a fresh suit. But even when you're filing a fresh suit, you must look through the laws that talk about the limitation, the time limitation within which you must bring an action to court. So if 12 years have lapsed by the time the action happened, it's going to be unfortunate for you. You will be time barred and your case will not be allowed again in court. So those are some of the key timelines that you must note, and if you don't keep them in mind, it is going to be unfortunate for you. You might either stay in court with numerous applications and appeal, or you might always be in and out of court. Now, the other important thing to consider when going to court is what orders are you exactly seeking from court? As you are going to court, what do you want court to do for you? This is a very important aspect because in most cases, yes, the court has wide discretion to grant any orders it may think deem and fit, but for proper adjudication and litigation of land matters, you must know what order you seek from court. Do you want a permanent injunction? Do you want a declaration? Do you want damages? Because if you do not plead some of these orders that you are asking for, the court may not give them to you. And it will be absurd to you. You have not used your land. Let's give an example. You bought land in 2012. You bought it 56 million. Unfortunately, you paid all this money and you have never, ever, ever possessed. You have never possessed this particular piece of land. You have never stepped on it. It is the other party who has been using it since 2012, so many years. Now, if you go to court and you are not seeking what we call main profits, Somebody will pronounce it as men's profits, but these are basically profits that accrue or that would have accrued to you by use of the land. But unfortunately, because you have not used it, somebody else has been deriving benefit. So if you do not seek for that benefit from court, it might be very hard for court to move its own, rather on its own, and say, okay, we're even giving you main profits for the last years that you've not been using. If you do not seek special damages in your pleadings and say, my lord, you see, because I've not been using this land, I had to rent somewhere, my cows had to be rented somewhere, to graze somewhere else for the past 10 years, because this gentleman closed off these so many paddocks and I couldn't access them. Now, if you do not plead those special facts, there is no way a court is going to move on its own motion and grant this to you. So, moving on, once you have mastered.
Council, thank you very much. Now, you talked something about the orders. Are people who own land, do they know these orders, or maybe before you actually know the orders, you're going to be asking court to help you put into effect? Because many of us don't even know which orders to ask for. How do I get the right that I need to be asking from court?
Thank you, Fred. It is true that many of our people come to us and ask, counsel, what should I do? So here it goes back to the professionalism of somebody who you have gone to, the expertise, the professionalism, and the care that they're going to give to your case. Of course, some of those things you will not know. But as an individual, my call to you is simple. Detail the truth to your lawyer. Detail every truth that concerns your case to your lawyer. With that, the lawyer is going to be able to know and find out what exact orders they should seek from court. Because if you do not disclose to me that you are the one in occupation of the land, I may not be able to seek certain orders. If you do not disclose to me that you actually had investments on the land that were probably destroyed by this person who trespassed on your land, I may not be able to seek for special damages. So the key element here is disclose to your lawyer all facts. Let your lawyer be the one to sieve out. Okay. Moving on, the other important consideration is that before you think of taking any matter to court, now this is for both litigants and the lawyers. The rule of thumb has always been ascertain where this land is. You as a client, let your lawyer visit this land. Allow your lawyer to come, look at the land, assess it, and know. Because we have always cried out on these spaces that land is not mere vegetables. They are not tomatoes that you're going to carry away. So there is no way as a lawyer you're going to litigate a land matter and you do not know where it is. This brings me to the next consideration that in any land matters, whichever court you are in, this court has to go and visit the land before it makes a final decision. Now, if that is a rule, and it is the law, you who is going to court, why do you want to go to court over a land that you do not know? I have seen Philip's good friend from abroad. My brother, do not allow your lawyer to simply file a case in court because you have instructed them, and for you abroad, you think you know the land good. The lawyer is telling you, let me go visit the land. You're saying, no, I know the land, it measures this, it borders so and so. Land changes. A lot of things change with the development on land, and this comes with time. So unless this lawyer or you, the client, knows where this land is located and what is on this land, that is the best way you are going to hope in litigating or arguing this case. So what happens is that when you are done with giving the evidence in court, which could be oral or document, you could give evidence through witness statements, or you come and take the stand and you cross-examine. But when all that is done, court has listened to the witnesses of the person who took the case to court, and also witnesses of the defendant. Then court will set a date and say, okay, we go visit the land. The reason for visiting that land is simple: for court to ascertain that whatever evidence you gave in court is coordinated to what is on ground. So if you begin having discrepancies in your evidence, then a little weight is going to be attached to your evidence. Secondly, the court, under special circumstances, can listen to witnesses on the ground who were not able to come to court. So all those are available within the law. That is why we have always advised that by the time a court of law comes up with a decision on a matter touching land, the RDC has nothing to do with it, because the court has considered the law and the bulk of evidence that has been presented before it. So you find an RDC not respecting a court decision, that is dismay. It is disgusting. I'll say it is very disgusting to people who respect the rule of law and who believe in the rule of law. Thank you very much, Yugaman. We can take some questions and comments. I've received a comment in my inbox that I am really fast, but apologies. We usually have quite limited time, and we want to cover a lot of these things. But for any more concerns and comments, let's have the questions coming.
I have quite a number of questions, Council, but maybe first let's hear from Council Phil. I'm sure he might be having some points to supplement.
Thank you, Yugaman. I wanted to chip in two things, and also thank you, Amity Realtors, for this platform. I wanted to chip in two things. One, for the listeners to appreciate that mechanisms like the office of the RDC, I have seen of these days, there's also the office of the national chairman trying to handle land matters, are typically mechanisms of a failing system which does not respect the rule of law and the justice systems in place. But your question was related to situations where the RDC will come in with police. Listeners should be critical. In such circumstances, most times there are also violations of human rights. Someone is incarcerated in a place unknown because they want to grab their land or because there was an issue on land. The Human Rights Enforcement Act and the new act, the amendment and the rules provide for taking action against individual armed police officers or armed officers that may be involved in such activities. Then second was the issue that council hinted on of the interim orders. The rules have also been amended to include an interim, where an order will be given that lasts for, I think, 3 days, because previously people would get an order, like council said, and give up on the matter for as long as they have an injunction. But there's a provision that a 3-day interim can be given, say if someone wanted to evict you or sell off the land or bring down a building. That space of 3 days can be given to see whether the matter can be halted or handled amicably between the parties before the worst gets to the worst. And lastly is the issue of visiting locus. I just wanted to tell a funny story of a colleague who handled the matter and at all times informed court that he knew the land and what was on the land. But then the opposite party kept saying, this is our land. It has our burial grounds. But this colleague had visited the land and he had never seen the burial grounds. So they asked for a locus visit. This colleague assures court that he knows the land and there are no graves. To his surprise and shock, that day he visited the land, there was a graveyard. Very fresh graves had been planted on the land. The judge had to take off, and the colleague unfortunately lost the matter in that way. So it is critical. You know the land, you're in occupation of the land, you have fenced off the land, So you know that by the time you claim it is your right, it is within your right, you really have possession, and you know that you're going to court to argue that a right to land has been taken away from you. Thank you.
Council, you actually know making me very suspicious if I ever go to to buy land and there's a graveyard. We might be forced to check one of them if it's real, because it looks like people are not sleeping. That's a that's a very funny scenario. Okay. All right. So I have some questions here, Council Alan. What one person says, this is actually in my DM. We love to get justice on land and our properties, but the cost of lawyers and the cost of the process fails us. How much should one prepare in advance if one is to go to court, say for a case of land that is worth 65 million shillings? Then number two, are there any organizations that can provide free service in that effect?
Okay, thank you, Fred, and thank you for the question. Uh, when I was preparing for this chat with my team, we said that a question we cannot run away from is that. I am happy it has come, and the best answer I'll give is that I don't know how much money it will cost you, simply because I do not know what the nature of dispute is. There are so many disputes that might arise, and there are a lot of factors that we put into one as lawyers when we are determining how much to bill you. Of course, we have our rules and guidelines that we follow while billing clients, but also clients must be aware that that when filing a case in court, there are fees that you pay. There are legal fees. They're actually called filing fees, court filing fees. Some of these are very standard court filing fees and are available, by the way, information that is readily available to the public. But you have gotten a chance. You now know that at least you need a lawyer. I am happy for you. The next consideration, which will not be a hard one, is for you to now ask yourself, which lawyer do I go to? We are used to this as lawyers. A client will come into your office, do a consultation, and move on to the next lawyer. Exploit that chance, exploit that window. Forum shopping is still allowed. Walk into my chambers, sit down with me, have a detailed conversation with me, allow me bid you for consultation, pay it, let me give you my knowledge on your dispute. Feel free to go to another lawyer and consult. Okay, now the challenge is what forms the basis of usually the decisions we make to go to court are not usually informed decisions. You will go, and because you have a friend who works at court, who works somewhere, who has a little bit of the knowledge, has advised you this way, you say, yes, this is the right advice, and you will take that matter to court. But we discourage that, and we have always requested people to reach out to proper lawyers, or what we call enrolled advocates, with addresses and law firms to guide properly. Sometimes we have had crooks that have penetrated our circles, and they have taken chance. They have taken chance of the unsuspecting clients or the public. They charge you exorbitantly, but before you know it, you are dealing with a crook. A male lawyer who knows the law and knows what they are doing is going to detail for you every single penny you are paying for. They're going to detail to you all the costs that you're going to incur and what it will amount to. So thank you very much.
Thank you, Council. The other question is coming in from Jennifer. So Jennifer says, what if I actually halfway the court process, I discover that I need to just lose interest because I'm losing a lot of money. What would you advise for someone in that scenario?
Thank you very much, Jen. My advice for somebody in that scenario is go back, listen to this chat, how it started. Before you even think of going to court, look at all those considerations we have talked about. Tick one by one. Do I have the witnesses? Yes, I have them. Will they come to court? In other words, if you have done a thorough preparation, there is no way, however long the case may take, that you will think of dropping out. Sometimes these cases take long for genuine reasons. You reach court today and the judicial officer is away, probably on official duties. You come back tomorrow and opposite counsel is genuinely sick. You come back another day, it is going to be you who's going to fail to go to court. But if you know that you're on the right case, that you did your background check, you did your preparations, you are not going to lose hope in this matter. However, should you feel like giving up in the matter, still, at whatever stage your case is, open up to another attorney. It may not be your lawyer this time, or it could even be your lawyer. Start with your lawyer. Sit down with them, tell them, honestly, counsel, 7 years litigating my plot of 65 million. I have now spent 80 million. Do I have hope? Listen to what your lawyer says. Still move on. Go to another law firm. Pick out another lawyer. Tell them your facts. Share key documents. Listen to what they have to say. If you have advice of about 2 or 3 professionals, then you can now be able to take an informed decision. My challenge is you listening to what we call bush lawyers. Avoid those bush lawyers because at times they are not going to give you genuine opinions. Thank you.
Thank you, Counsel. Then the other point someone is actually pointing at here is at a point where, for example, you have land that has had issues for a long time and you have not been using it. So they're asking, are there possibilities in some scenarios where one can be allowed to use land as court proceedings are going on?
True. That is what we've been talking about. And when we are discussing here, we talked of what orders to seek from court. But when you file a case in court, there are what we call interlocutor applications. You could apply to court and say, yes, whereas I have been sued for crossing the boundaries of my land and going to the other person's land. I had planted my gardens. I pray to court that such status quo be maintained. Court allow me harvest my gardens until probably such a time or it disposes of the suit. So those are what we call interim orders or temporary orders. They last a certain period of time to serve a certain purpose because we have known that land is a delicate thing. Some people derive sustenance. Their whole life depends on the land. So if it is a farmer and he has this banana plantation, you are not going to stop that man from using that banana plantation when he has used it for the last 10 years simply because there is a boundary dispute or simply because somebody from nowhere sold to you that piece of land when you didn't do due diligence. So yes, in most instances, you will get these orders from court allowing parties to use the land as they have probably been using it until such case is determined. Thank you.
Henry says, hi, Yoga Man. Please help me ask counsel. Some cases are ridiculously too long to get finished, take ridiculously too long to get finished or to get done away with in courts. What is the average time of a court case and what factors bring about cases that take more than 10 years plus for that to happen?
Thank you very much, Fred. I'll begin with the factors that take cases long to, rather, why cases take long in court. Number one, it begins with the nature of your lawyer.
If your lawyer is not open to you, you might find yourself in trouble. This could be a lawyer who has found a cash cow. Lawyers know what we talk about, but even you businessmen or anybody near that business, you know that once you have that paying client, sometimes you're going to find, we have called them dubious lawyers, who think this is a cash cow, I should always be milking. So they will not want your case to end. There is a funny story that is always told to every lawyer, I think, in their year one, that a father was a lawyer. So he educates his son, and his son becomes a lawyer too. So this son comes to a law firm and finds this case that is 30 years old. Then, now that he has started going to court, he goes to court once, twice, and then successfully. These are the times when his father was away, the senior lawyer was away. Now, this young man concludes this case and is very happy. He comes back to chambers. Dad and senior counsel is back, and then the junior lawyer is telling Dad, Dad, today was a big day for me. Dad is like, okay, please share the good news. You remember that case of 30 years, the one that you started even before I was born? Dad says, yes. I have won, I have completed it. Of course, he had won it. I have won it, I've completed it. And the dad sat down, held his head in his arms, and said, oh my God, you don't know what you have done. That is the case that educated you, your brothers, and your sisters. It is the only case that has been sustaining us. That is why I have spent all that time telling you the number one factor is the nature of the lawyer you have. Second factor is the nature of the case. This could be a case where you are suing so many people. And the challenge with suing so many people is that each of these persons, if sued individually, has to respond individually to your claim. Now, if these people do not have one lawyer, let's say I am Alan Msasle, I am suing Philip Munavi and 24 others for trespassing on my land. In most cases, if these 24 people do not get the same lawyer, each of them has to get a separate lawyer and respond independently. Yes, they all have the same timelines, but for you getting the same schedule is going to be next to impossible. Imagine you have 6 lawyers in a case. Now, this comes with due respect to matters where we have had many lawyers handling them. But the gist of this is that when court is giving you the next court hearing date, it wants to be sure the date is available to all of you. Still, that is an issue with the lawyers. Then the other consideration is that their clients who simply want to use court as delaying tactics. People will report cases to court or file cases in court and they will not show up. They will feign all cases of sicknesses. So, in instances like those, we must be cautious and know the nature of clients we are dealing with. But then the other issue is the nature of the cases that we are dealing with. When you're dealing with a land case, we must know that this is a case that touches the livelihoods of people. Now, when there is a land case, it is not a case that you're going to rush, because when you rush, you are making decisions that are affecting people. You want to give everybody involved the benefit of the doubt, to have their evidence heard. So that is also the other factor, but the other one is simply a legal principle that let each party be heard. If somebody did not file their defense in time, they're probably going to be accorded another chance to be able to come to court and urge out their case. So briefly, those are some of the factors. If I missed out any other aspect in the question, please remind me, Yugama.
Thank you very much. Ladies and gentlemen, I just want to remind you this conversation is powered by Amity Realtors, a real estate agency in Western Uganda. And of course, they are your number one source of affordable land, agricultural land, farmlands, prime plots, and of course also commercial plots. Please do reach out to Amity Realtors on Mackinson Street. That's in Imbara. You'll be Chosga House. That's where the office is. You'll be able to get in touch with them and they will give you your land solutions that you're looking for. And also, I just want to remind you that we have had almost 8 episodes behind before today's episode. So if you want to catch up with all the conversations we've been having, please check out Amity Realtors YouTube channel. All the conversations we have had in the past are actually there. It will also help you to be able to follow through on some of these issues that we are currently discussing. Now, also, I have a request here from Herbert. I think Herbert wants to say something. Herbert, can you hear me? Herbert, can you hear me? Yes, Herbert, can you hear me? Okay, I see Herbert is on. Herbert, please unmute your mic so we can get to hear you speaking. Oh, okay. Do we have a network issue here? Council Philip, can you hear me?
Yes, I can hear you.
I think maybe we have a network issue with Herbert. I see Herbert is on. Herbert, please unmute your mic and have your say.
Yugaman, maybe there's a person who asked a question whether they are free legal services. Yes.
Oh, yes, please. Go ahead on that.
Legal aid clinics. ULS, Uganda Law Society, has a legal aid and pro bono scheme. LDC also has a legal aid clinic, so people can walk into these facilities for free services. Maybe the other issue I want to hint on is the myth among the people that lawyers' services are very expensive. Yes, they are very expensive, but our listeners should also appreciate the fact that there is a lot involved in litigating their matters. I'll give an instance. You start a land matter with a small wrangle. Someone has grabbed my land, blah, blah, blah. Then midway, you have to put in an application for an injunction or something. After that, you have to do a transfer of the title. So you see that there are consequent transactions that may come along the litigation process that require appreciation from the client and are costly by their nature. So litigation by its nature, not only land matters, but more specifically land matters because of the nature of the gravity of the issue and the factors involved, it is necessarily expensive. We have also seen clients who will say you're charging them highly. They go to another person or firm, or they choose to pursue the matter on their own. But later they come back, or they later move to a firm that will charge them even higher fees. So the issue is appreciating the service that you're going to get and knowing that it is your right that you're fighting for. And at the end of the day, if you become successful in your matter, it is your rights that you have reinstated or property that you have obtained. So it is about appreciating the service that you're going to get. Thank you.
Fantastic. Thank you very much. I had wanted to get through to Director Herbert, one of the directors at Amity Realtors. It looks like he has some bit of network issues, but nevertheless, we'll get to him maybe next week or during the course of the week. We can be able to make some posts. Council Alan, I would love you to give your parting shots and, as usual, to give us the key takeaways from today's discussion as we conclude.
Okay, thank you very much. I don't know whether I'm audible. I see Council Philip Munavi still speaking.
No, you are actually very audible. I think there was a bit of network issue on your end. That's why you're having that kind of feedback. But Council Philip is actually muted and you're audible. We can hear you.
Oh, all right then. Thank you very much, Fred. As we close off for today, I would like first of all to appreciate our colleagues that have come in. I have seen quite a number of new faces today and respectable people in the profession. For your information, the president of the Uganda Law Society, Mr. Bernard Owundo, has been on the call, and I appreciate you, Mr. President. He's my boss. I have seen my former lecturer, Init Edroma, has also been on call. These are respectable people in the profession, the few that I could recognize. But as we part for today, court is a serious business. Like land is a serious issue because it's a factor of production. It is actually one of the best factors of production. Leave for say for today, where we now talk about the internet, but land still remains one of those best factors of production. So if you have any dispute over land, it is very considerable that you take it as serious and with all the seriousness it requires. If it requires hiring the most expensive lawyer in town, please do, because once this piece of land is taken away, it is going to be your right to life that is being affected. Now, before you go to court, make sure you have a solid case. I'll call it a solid case. In the start, I called it a cause of action. Make sure your case is solid. Do I have the evidence? Do I have the witnesses? Do I have all those agreements? Will these witnesses come to court to testify? Then secondly, have I exhausted all possible remedies that I would have asked for outside court? Have I tried to have this matter mediated? Why am I saying this? Land and land disputes or litigation is quite expensive. It is quite timely, it is consuming, and it is stressful. So when you're thinking of going to court, have all these considerations, know every fact about your land, know your land, get a good lawyer, find out the timelines. Okay? Be well versed with the process that is going to take place in court. Do not just be ambushed, and before you know it, you are testifying and you thought it was just a casual discussion. Because once you have finished testifying, you may not have that other chance to come back and tell your story or submitting any other evidence or documents in court. So, to cut the long story short, litigating in land matters is a serious matter that should be given all the seriousness and attention that it deserves. Thank you very much for listening to me. For those who came in late, I have apologized for not having been available the previous time, but also thanked my good brother and friend, Mr. Philip Munabi, Council, for having done justice to the topic that we had last Tuesday. So a blessed night from me to you, and see you next Tuesday.
Council, before just you go, I've got very good news here. Amity Realtors has really some hot deals for you guys who are on the space and people that you might know out there. Now, they have some new properties in Kafunjo, Ishanyu too, and just adjacent to the Buffalo and Las Vegas Hotel at the bypass. Now, they have plots starting from 24 millions, 48, and if you want an acre, at 190 million shillings. They also have a discount offer where you start by paying 30% of the value for the land, and then you can finish the rest of the balance in about 3 months. And here plots in Karunji Estate with the title go at 80 million shillings. That is 8 million shillings. And bypass in Kafunjo title, the plot is at 24 million shillings. Of course, if you want to contact Amity Realtors, please call them on these numbers: 077 75 64 588. I will be able to share, actually, let me share a post after this conversation for some of you that want to see these, and maybe you never know, one of your friends or yourself, you could actually go and take up these properties. I am very thankful to everyone, each and everyone that keeps coming back every single Tuesday. I want to encourage you guys, please go check out Amity's YouTube channel and listen to these conversations. You just don't know how much these conversations will help you until you have someone you're going to save, or until yourself you're at a point where you need something from these conversations. So I want to thank Amity for always powering us. I also want to thank Council Phil and Council Alan for always showing up and sharing the knowledge with us in a way that is very, very understandable. And of course, we will be back here next Tuesday with yet another conversation for a very, very interesting engagement. From me to you, have a fantastic night. Please get better, not bitter. Tough things should never change you from pursuing your goals. And of course, condolences to those that have lost loved ones and to those that are not doing well. We pray that next week you'll actually be much better and in better spirits. Good night. God bless you all.